make, use, or sell the invention, you're going to be infringing. Yeah?
So none of the information about the recipe, let's say for Gatorade, would be released to the public until the patent is expired?
No, it's actually, if it's in the patent, it's released to the public. Because again, you have to meet the written description requirements. But you can't, so the idea is to let the public benefit from the knowledge and use it as a building block to make other things, but you can't copy what's there.
Okay.
You can't just use that recipe and say, I'm gonna make Gatorade today in my garage. That you can't. But the knowledge is out there so you can build on it. And so once the patent expires, as they are now, you can go ahead and make it at lower cost. And we see this a lot in the generic drug area.
So Coca-Cola is maintaining its own formula. It's not available in the market.
Well, that's right, because it's not patented. It's the formula for Coke is a bit of a legend because it's been around since the 1800s. It's not patented. Instead, what they decided to do is put it under a new set of laws called, at the time, called the trade secret laws. Trade secret laws last forever, and that's why the Coke formula has been so secure. Is that the Coca-Cola company keeps that formulation under wraps, and it can't be reverse engineered. So now, if they had gotten a patent on it, the patent would have expired long ago, and anybody could make Coke.
So why companies don't do that? Since this is a patent, they just will have the thing.
Yeah, right. Well, there's a that's actually a good question because there are advantages and disadvantages of going through the patent route or the trade secret. You know, briefly, the patent gives you a limited time frame. The trade secret can last forever. The patent is expensive to get, but can be enforced in court, in the federal court, for an infringer. The trade secret is relatively inexpensive because all you have to do is meet certain procedures under the Trade Secret Act, but it's harder to enforce those kinds of things. So, from a business perspective, you just have to look and see which fits better. Also, you have to look at the technology too. I mean, if it's something that can last, it's long lasting, you may not want to get a patent. You know, a lot of technology, especially computers and electronics, even though you get a patent on it, the technology and genre has moved on in 18 months. So the patent, it really doesn't have a lot of value. You know, with a trade secret, like with the Coke formula, that can last for a very long time. You know, it used to be made with cocaine, that's why they call it Coke. Now they use caffeine. But so the formula hasn't been tweaked with very much for a long time. Yeah.
So for Gatorade, would the thing that they're patenting, would that be the chemical composition, or would it be the actual ingredients? Like if you go online, they'll tell you the ingredients, like they put however much of this,
Yeah. Yeah. It's probably a composition patent. It lists it out as a recipe. It says, a sports drink comprising, 2 parts water, a half a part of, orange flavoring, 0.1 part electrolytic mix. So it's got a list of ingredients in the claim. So it says as a composition. And then if you read the description of what the patent is, it'll tell you how to make it. So it'll say, cook the water, boil the water at a certain temperature for so long, add it, follow it like a recipe. That's really what it is. Okay, so right to the patent owner. So if you infringe the patent, or if you make or use or sell the patent, the subject matter of the patent, you're infringing the patent. Okay, so what does this mean? The patent owner, which again can be the university, a company, or an individual, can make, use, or sell the patented invention himself and prevent others from making, using, or selling the patented invention. Now, I've mentioned this in passing, but I haven't explained it yet, but patents are treated like personal property, so they're like your car. So you can sell your car, or you can buy a car. It's that kind of thing, or buy a house. So the owner can license the rights to make, use, or sell the patented invention to someone else. So that's basically me retaining ownership of the patents, that I'm giving you permission to infringe, and I won't sue you. That's basically what a license agreement is. So I'm giving you, under a license agreement, I give you permission to use my patent, and I promise I won't sue you. Or I can assign the rights, where this is where the ownership changes. I will sell you my patent for $100,000, and you can be the new owner. Yeah.
Is there protection for people who are doing research? If you want to improve on the process and you need to undergo the process in order to improve on it, or
Yeah.
do tests,
Yeah.
do you have to purchase a license, or are you allowed to do that for free?
Yeah, it depends what you're doing. There are some doctrines in the law that allow for some research, in other words, they allow you to infringe a patent if it's for academic or certain uses. Usually what happens is when the law will let you infringe to that degree, but once there's any kind of money exchanged, or if you use that particular patent process, for example, and then you turn around and start making money off of it, that's where they draw the line on it.
So essentially, they have the right to all the improvements on their patent as well until it expires, unless they license out.
Yeah, that's right. And, universities get into trouble for some of this because they really don't, it's not really clear where the line is. It's very fact-based. Depends on the situation. It's one thing to, use a patented process from a big company, in passing. It's one step in a set of 12 steps. But if you're actually doing that in an academic lab and then turning around and licensing out some other kind of technology to someone else, that's a different question. It all depends on what the facts are. But in general, there are certain exceptions to infringement, and that's one of them. Yeah.
Just to touch on what you were saying, so let's say it's basically infringing if you're making money off of it. So if I looked at the patent for Gatorade and wanted to make Gatorade for myself and just use it for my personal use only, would that be infringing on their patent? If I'm not selling it, I'm not giving it to anybody, I'm just making it and using it myself?
Yeah, it would be.
Okay.
Because what this example, what he was talking about was a specific academic research example, and that's a specific carve-out. What you're talking about, we'll just say that the patent is enforced, and assume it's enforced. What you're talking about is blatant infringement, where there is no exception to that. So yeah, you would usually, as a practical matter, Gatorade wouldn't come after you.
I mean, they wouldn't know about it, not,
Yeah, well,
wanting it. If I could,
Right,
do that
they wouldn't.
specifically for your own matter, they're really not gonna find out.
Yeah, that's right, and that's a whole other issue, is how do you detect infringement?
Yeah.
In your example, you can't detect it if you just ruin it, do it a home brew.
Right.
No one's gonna know. But if you start selling it and say, hi, here's my new reformulated Gatorade,
Right.
They'll come down on you with like a ton of bricks. Okay, so I mentioned this a couple of times, but everything I said right now applies to the United States only. There are foreign patents available. The patents, as I mentioned earlier, have a territorial effect. They're only good in the United States. If you want to get a German patent, you got to apply for one in Germany, and basically go through the same rigmarole that I just described, where you apply for the patent, it's examined at the German Patent Office, and they'll go through and issue you one on pretty much similar terms. There is no world patent. Right now, you have to basically go country by country. What there is, however, is what's called a Patent Cooperation Treaty, which provides for a single document to cover a number of countries at once. It's a very efficient process that I use a lot with the clients that want to get worldwide protection. Ultimately, they're going to have to get individual patents, but at the very beginning of the process, filing a single application that covers most countries in the world is usually good for them. So I want to talk a little bit, just in closing, about what I do every day, and my qualifications and how I got to where I am. Who can practice before the patent office? Well, you don't have to be a lawyer, but you do have to be registered by the patent office. There is a special bar exam, an examination that you have to take. You have to take and pass that exam, and they give it online a couple times a year. And you also have to have a bachelor's, at least a bachelor's degree in what they call a recognized science, which are the typical, any kind of engineering is good, chemistry, physics, biotech, biology. There's a whole list of what the technology areas are. And if you're interested, you can go to uspto.gov and see what the latest requirements are. After you pass the exam, you're admitted you can talk to the patent office and represent clients, either as a patent agent or a patent attorney. A patent agent is not a lawyer. You know, it's a person that has simply passed the patent bar. And this person has certain limitations as compared to a lawyer. They can't represent an inventor before any court, because only lawyers are allowed to represent clients in front of the court. And you can't give a legal opinion on patent validity or patentability, because again, that's a legal matter that simply isn't covered by the patent agent. The patent attorney, on the other hand, can do these things. He can represent an inventor before court, and he can give legal opinion. But you gotta go to law school. Just to give you a flavor for what I do, the types of what I call patent prosecution, that is dealing with inventors, talking with inventors, and getting patents through the patent office. I prepare and file patent applications. As I alluded to earlier, I work with inventors to define what the invention is. You know, is it a compound, is it a process, that kind of thing. We search the prior art to see what else is out there. I mean, we mentioned earlier, if the invention has already been patented, you can't patent it again. So we have to know that up front before we go further. Yeah.
Could you elaborate on that process, how it begins, how long it generally takes, where you go? You say that? You just call up the patent office and say, hey, I need all your stuff on this?
Oh, no. The way it generally works is inventor will come in, we'll sit down and talk about the invention. He tells me what he's got, what's been developed. And then I'll do a search on the prior art. Basically, you can do this through Google. We have a number of resources in the office that allow you to search prior patents. And it's not just patents. You know, you got to search technical literature too. You know, the Journal of the American Chemical Society.